The Supreme Court of India today continued hearing the batch of petitions challenging the Karnataka High Court's verdict which upheld the ban on wearing of hijab by Muslim girl students in educational institutes in the state of Karnataka. Today was the fifth day of hearing by a bench comprising Justices Hemant, Gupta and Sudhanshu, Dhulia. Arguments were advanced by Senior Advocate Aditya Sondhi, appearing for an intervenor, and Senior Advocates Rajeev, Dhavan and Huzefa, Ahmadi, appearing on behalf of the petitioners. Today, Senior Advocate Rajeev, Dhavan, appearing for the petitioners, argued that once a practice is shown to be bona fide, it is permissible. He also argued that the Karnataka government order is based on false foundations inasmuch as the decisions cited by it to ban hijab in schools were passed in an altogether different context. Senior Advocate Ahmadi argued that the impugned government order against wearing of hijab in schools misunderstands the concept of fraternity and confuses the same as the antithesis of diversity. He argued that by prohibiting hijab in schools, the state has virtually forced Muslim girl students out of schools. He also argued that even if it is found that the hijab is not an essential religious practice, it will be a cultural practice and thereby protected under Article 29 Clause 1 of the Constitution. Whereas Senior Advocate Sondhi, appearing for an intervenor, has relied upon a Nigerian Supreme Court decision which held that the prescription against wearing of hijab in schools is illegal. He also argued that the impugned Karnataka High Court decision forces Muslim girl students to make a choice between right to freedom of religion and right to education and is therefore a case of indirect discrimination against them. In this video, we will have a look at all the arguments advanced by the senior advocates and the exchanges between the bench and the counsels in detail. We have also covered in detail in our earlier videos the arguments advanced by the concerned parties and the courtroom exchanges that took place during the prior hearings. The link to these videos have been given in the description box below. Please do check it out. Today before the Supreme Court, Senior Advocate Dhavan referred to the Supreme Court's decision in the Bijou Emmanuel case wherein it had been held that once it is shown that a practice is bona fide, then it is permissible. He said that the High Court's finding that since Quran does not prescribe any punishment for not wearing hijab is not mandatory is puzzling. The finding, he said, ignored the fact that millions of women wear hijab bona fidely. Dhavan argued, and I quote, "According to the tenets of the faith, if something has been followed, it is allowed. If it is bona fide, you don't have to go back to the text. We have to examine if the practice is prevalent and is bona fide. What is the dispute whether it is an essential practice? If all over India hijab is practiced, lordships will only see if it is a bona fide practice." Highlighting further that if hijab is permitted in public places, then why it cannot be permitted in classrooms, Dhavan contended, and I quote again, "Hijab across the board is permitted in public places, so what is the basis to say hijab can't be in classroom and is opposed to public order? When you say you can't allow burqa in school, it is reasonable because you want to see the face. But what reasonable objection can be there to the headscarf?" He also apprised the bench that in certain states, for example the state of Kerala, has taken a view that the hijab is a farz. At this point, Justice Gupta asked Dhavan as to what is the basis of saying that the hijab is a farz. Dhavan responded by saying that the Kerala High Court, in its judgment holding hijab to be an essential practice, referred to Quranic injunctions and the hadiths to conclude that it is a farz to cover the head and to wear the long sleeve dress except face. He also said that he does not accept the courts to be Maulvis. However, if we were to interpret the text, the answer of the text is that it is a farz. He added, however, and I quote here, "But I don't go that far. If it is a ritual that is prevalent and is bona fide, your lordships will allow." To which Justice Gupta inquired, and I quote, "Regardless of the mandate of the holy book?" Dhavan responded saying, and I quote again, "Provided it is not against the holy book, to that extent enquiry can be there." Dhavan also referred to the Government of Karnataka guidelines of July 2021 to argue that no uniform was mandated in the educational institutes back then and thus hijab was permissible. However, suddenly in September, the students were heckled and were discriminated against allegedly. Pertinently, Dhavan pointed out that the impugned government order, which excluded the right to wear hijab, is based on a Kerala High Court's decision against hijab, but fails to consider that this particular decision was rendered in the context of a convent school. Dhavan also said that across India and across the world, hijab is recognized as valid. The only justification given by the Karnataka government is that schools are qualified public places, and that by itself cannot be a justification, he argued further. He also pointed out that Kendriya Vidyalayas permit the hijab. Now let us see what are the arguments that were made by Senior Advocate Huzefa Ahmadi today on behalf of the petitioners. Ahmadi today emphasized that by prohibiting hijab in schools, the state has virtually forced Muslim girl students out of schools. He argued, and I quote, "If somebody is getting provoked by the hijab, he should have a sense of brotherhood and fraternity. Does the state's priority lie with promoting education or with this? Is the hijab so very intrusive that you have to ban it?" During the hearing, the bench also discussed that the dropout rates among girls is very high, but this was not argued before the Karnataka High Court. Justice Dhulia said that while addressing the counsels that before the High Court, the petitioners had only argued the essential religious practice test. Justice Dhulia then asked Ahmadi if they have authentic figures of students who have dropped out of school. Ahmadi informed the court that as per the information available with them, 17,000 students abstained from the examination. Ahmadi also argued that the legitimate state interest is in encouraging education, especially among minors. Is it legitimate state interest to adopt a restriction which will encourage dropouts? He asked during the hearing. He also showed portions from the government order that mandate students to behave in a fraternal manner and transcend their group identity. He quoted portions from the government order which state that students carrying religious observances is an obstacle to unity. At this point, Justice Dhulia remarked, and I quote, "When they wrote the government order, they may not have been aware that it would be put to this scrutiny. Perhaps they mean peace should be maintained. The High Court judgment also says that the government order could have been better worded." In response, Ahmadi underscored legitimate state interest is to encourage diversity, not to have standardization of all practices. Why should someone feel that someone's religious observances obstruct secular education or unity? Why should someone get provoked if someone wears hijab and goes to school? If it provokes, you have to address that, otherwise you're allowing someone to be bullied. You hardly want that to happen in campus. Ahmadi also pointed out that Muslim girl students were earlier confined to madrasas and they had broken stereotypes to join secular education. However, the impugned government order takes away that from the students, as the students consider it to be an essential practice, and therefore they will be forced to go back to the madrasas. However, objecting to this particular argumentation, Justice Gupta pointed out that there is no pleading which states that these students are from deprived sections. Justice Dhulia then asked Ahmadi if it is his argument that the girls don't want to wear hijab and they are forced to. He responded saying that the parents might ask the girls to go to a madrasa and not to school, and also pointed out that he has a detailed report of the People's Union for Civil Liberties on this. Justice Gupta then expressed his reservation on neutrality of the PUCL report by pointing out that it starts with the title Critique of the Karnataka High Court Judgment. If the basis of the report is the criticism of the judgment, probably the basis is not right, the judge said. However, Ahmadi submitted that he is merely referring to the testimonials of the affected girls. Ahmadi also argued that the Karnataka Education Act promotes unity in diversity and that the impugned government circular is against the objective of the act. He pointed out that the government order was also applied retrospectively. While it was issued in February this year, girls were stopped from December 2021. Now let's move on to the arguments advanced by Senior Advocate Aditya Sondhi. Sondhi at the outset pointed out that the state has argued that the government order prohibiting wearing of hijab in educational institutions is innocuous. Sondhi, however, raised the issue of indirect discrimination, a principle recognized by the Supreme Court in the case of Lieutenant Colonel Nitisha versus Union of India, that is a Permanent Commission for Women case. Sondhi then cited Greek writer Aesop's fable about serving soup on a shallow bowl to a fox and a stork. He argued, and I quote, "Though shallow bowl is seemingly neutral, the stork can have the soup because of the long beak. So seemingly neutral measures can have greater adverse impact on certain categories." He also argued that the interfaith differences, inasmuch as Muslim girls do not wear hijab, cannot be a ground to restrain those who wear one. In this regard, he also cited the National Education Policy, which he said emphasizes on an inclusive education. Pertinently, he also referred to a recent judgment of the Supreme Court of Nigeria in Lagos State Government and others versus Asiyat Abdul Karim, which held that the prescription against wearing of hijab in schools is illegal. In this case, the state of Nigeria had imposed a ban on wearing of hijab except on religious days. The country's Supreme Court, however, reversed it by a 5:2 majority. Sondhi submitted that the majority judgment held that nothing was shown to establish that hijab will violate the fundamental rights of others and will lead to chaos or disunity. The hearing in this case will continue tomorrow before the Supreme Court. Thank you. I'm Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.